Last week, the trademark office ruled 2-1 against giving the trademark approval to the Washington Redskins owner Dan Snyder, and everyone went off with their opinion. But what exactly does all that mean? We're going to talk to somebody who knows. Intellectual property and patent professor at St. Louis University Law School, Yvette Liebesman. Yvette, welcome to Big 550 KTRS.
Good. Thank you it's nice to be here.
You got it. All right. First, explain. Do you have to go back and re-up your trademark every couple of years?
You don't have to re-up it every couple of years. There are fees that you have to pay along the way. What happened here is a group of Native Americans sued to have what's called the mark canceled. They said, this is offensive. It never should have been granted. We want registration to be canceled.
Okay, so they went about their own, and so then the Redskins had to defend it.
Correct.
Okay, what did the Redskins lose? Did they lose the rights to say Washington Redskins? Can I sell a shirt that says Washington Redskins? Can I use their logo? What was denied?
Well, right now everything's on hold, so I wouldn't be making those T-shirts quite yet.
Thank you very much. But what if it is upheld? Okay. What did the Redskins lose?
Well, the Redskins could lose their right to enforce it. But even that's iffy because you don't actually need registration to have an enforceable trademark. As soon as you are using a mark in commerce in connection with goods or services, you have rights in it. So like the first time Starbucks sold a cup of coffee, even if they never registered it, they had
prior use.
They had prior use. They had rights in the mark related to coffee. So the Redskins have rights in their mark anyway as an unregistered mark. And one of the things that you get with registration is what's called constructive rights, nationwide constructive rights. Normally, when you have an unregistered mark, you only have rights to that mark where you have market penetration. Redskins are nationally known, not really an issue. Now, even if they lose registration, it's iffy as to whether or not they would still have federal rights as an unregistered mark. Because some courts say that, well, if you can't register it for statutory reasons, you don't even get unregistered rights. But they may very well still have rights as an unregistered mark in federal court.
What was the reason the trademark office said this is too offensive, we should not protect this trademark?
Well, what they do is they look at the time that the mark was registered, and they say, was this an offensive term back in I think from the 1960s to 1990 was the last registration. And the registration included both the word Redskins and some older logos that they really don't use much anymore, but are very similar to the logos they use now.
Right. And so they said when this was granted, it never should have been granted because it was offensive back in the 60s?
That's pretty much what they're saying, yes. That's one way that you would cancel a mark is to say it was offensive back then.
So they said we never should have given it approval in the first place.
Correct.
So, if this team still has trademark rights, they can still continue using it, and will they, or will this fall on them as more of a moral issue?
It's more of a moral. It's really more of a moral victory. So even if they don't have registered rights, first they may still have rights as an unregistered mark under federal law. But even if they don't have those, every state has its own trademark law. So if a state chooses not to follow along with the federal government and deny rights, they could go after people in each individual state. Perhaps Missouri would like to keep the mark, and so somebody sued here in Missouri for making T-shirts under state law. Redskins could still enforce their rights here. But even if they have rights as a federal unregistered mark, and even if they have state rights, the one thing they do lose, which is pretty big, is the right for customs to stop enforcement at the borders. So pretty much our tax dollars will no longer be used to stop what would otherwise be considered counterfeit goods from entering this country. So then once they were sold, it would be up to the Redskins to stop the infringement versus our tax dollars doing it for them.
What about the freedom of a business to put a racial logo and a racial saying on a T-shirt? Did the Washington Redskins lose their First Amendment rights by doing this?
They can do anything they want. They can continue to use the mark as much as they want. All the federal government is saying is that we're not going to enforce it as a registered mark. We're not stopping the federal government is saying we're not stopping them from using the mark. We're just saying we will not enforce it as a registered mark.
What about the NFL? They're part of an NFL, which is sort of a weird group of billionaires to begin with. Does the NFL, are there any effects on the NFL logo or part of the Rams because they're sort of affiliated with the Washington Redskins? What does that interfere with this at all?
It's hard to say. The NFL makes money off of this, so obviously any enforcement that they have to pay for themselves versus Customs doing it is going to cost them money.
And the Redskins are appealing, so this could go on for years.
It could. And the last time it went, it did go on for years. This is actually the second time that the word Redskins has been canceled as a mark. This was done previously in the 1990s, and then it was overturned because they said the plaintiffs at that point had waited too long to enforce their rights. Basically, what's called latches. If you wait too long, you can't enforce your rights. This time what they did is they took a whole bunch of really young people under the age of 24, because you can't enforce your rights until you're a legal adult, until you're 18. So they took a whole bunch of kids who were between like 18 and 24 and got them to be the plaintiffs. So then there was no longer latches because they were enforcing their rights within the statutory period.
So they found a loophole.
Well, it's not a loophole. It's something that
it's those rights were being infringed
Exactly.
on.
The rights are being infringed on. They found...
That's your loophole. That's my right.
Well, but they didn't do that the first time. So, I mean, they went back to look for a way to get around it, I guess.
Well, actually, they didn't. They actually had both lawsuits going on simultaneously. When the first lawsuit was appealed, the second lawsuit was actually already in the courts, was already starting to work its way through. So they actually had split it up into two sets. They were actually concerned at the time of latches with the older group. Exactly.
Yvette Liebesman is with us, intellectual property and patent officer at St. Louis University, Law School. We have about a minute. They say that the way we distribute patents in America needs to be completely overhauled, and that big companies are destroying the little guy who is inventing the next great thing in his garage because the big boys are destroying him.
Well, I think one of the bigger issues involving patents is that we're letting too many bad patents through. The Patent Office does not have enough resources to hire enough patent examiners to really make sure that only the good inventions deserve patenting, that they meet all of the statutory requirements. And yes, there's a lot of pressure on them, especially from the bigger companies. But that's if we issued better patents,
we wouldn't have a
we wouldn't have as big of a problem. Once you start getting a lot of the problems when you don't have good patents, and when patents are broader than they should be, when you're patenting ideas instead of the actual invention, what's called functional claiming. When you have things like that going on, then you're going to have lots of the problems we see right now.
Yvette Liebesman is the smartest person we've had in this studio in a long time.
Without a doubt.
Intellectual property patent professor at St. Louis University Law School. How are the new digs downtown?
Oh, they're awesome.
Good.
You should all come and see them. They are absolutely amazing.
Thanks for coming in. You were great.
You're welcome.
7:58.